Tonight, we revisit one case that became part of Scottish memory. One life, one investigation, one verdict that the record has continued to examine. The case of Jessie McPherson begins in Glasgow, Scotland, in the summer of 1862. Glasgow at that time was the second city of the empire, a place of considerable industrial and commercial consequence, its population approaching 400,000 souls, and its built environment expanding rapidly to accommodate the trades and professions that sustained it. The western end of the city, near Charing Cross and the upper reach of Sauchiehall Street, was in 1862 a district of prosperous residential terraces, of accountants and merchants and men of profession, their households staffed by domestic servants and their families accustomed to summering at the coast. Sandiford Place ran off that western end of Sauchiehall Street as a classical stone terrace built by Brown and Carrick between 1842 and 1856. 2 stories and a basement across most of its length. The stone-built frontages fitted with sash and case windows, the entries reached by short flights of steps from the pavement. The houses at the lower end of the terrace had sunk flats below street level, reached by a further descent of approximately 6 steps from the pavement, their windows looking upward at the feet of those passing above. These basement rooms served as kitchen and servants' quarters. It was in one such sunk flat, at number 17 Sandiford Place, that Jessie McPherson was employed as domestic servant and lived and worked in the summer of 1862. It was in those same rooms that she was found dead on the morning of the 7th of July of that year. The documented record of Jessie McPherson's early life is sparse, and what survives comes in fragments from sources of variable. She was born in approximately 1829, a figure cited consistently in later scholarship, though the initial police report entered by John Fleming placed her age at approximately 40 years, a discrepancy that was never formally resolved. The figure of 33 years of age at death is the more widely accepted, and it is the figure to which subsequent treatment of the case has adhered. The record falls silent on her precise birthplace, but testimony preserved in the Falkirk Herald in July 1862, drawn from the account of a woman named Agnes McPherson of Falkirk, who had been connected with Jessie's upbringing, established that Jessie had been raised in Falkirk, in the household of Agnes McPherson's own parents, both of whom were by 1862. Whether those individuals were Jessie's grandparents, foster parents, or relations of some other kind is not established in the surviving record. Her parentage is noted in the trial record under the form of her name entered for legal purposes, Jessie McPherson Richardson, the surname Richardson deriving from a man identified as James Richardson, described in the Falkirk Herald as her putative father. The record establishes that Richardson neglected Jessie throughout her life, and that, following her death, he appeared in Glasgow with the reported intention of claiming her effects, a detail that attracted considerable journalistic commentary at the time. Her mother is not named in any available source. She was known in daily life as Jessie McPherson, not by the Richardson name, and she appears never to have used the paternal. Whether she was illegitimate in the formal legal sense or had simply been abandoned by her father and raised under her mother's or guardian's family name cannot be determined from the materials that survive. She did not marry. She is referred to in no source as Mrs. McPherson, and the Richardson element of her legal name reflects paternal origin rather than marital status. She came to domestic service, the standard occupation for women of her social class in mid-Victorian Scotland, at a period that is not precisely documented. By some point prior to July 1862, she had obtained a position in the household of John Fleming, an accountant residing at 17 Sandiford Place, Glasgow. It was during that period of service that she formed a close friendship with another domestic servant in the same household, a woman named Jessie McLachlan, born Jessie Mackintosh around 1834, who had by 1862 left service, married, and was living with her husband and their young son in a tenement flat elsewhere in the city. Jessie McPherson and Jessie McLachlan remained close friends after McLachlan's departure from the Fleming household, and the friendship between them was well established in the recollections of those who knew them both. Contemporary sources describe McPherson as a quiet, hard work. No evidence of a negative character was entered in the record. She lived and worked in the sunk flat of the Sandyford Place house, in the kitchen and the servant's bedroom below street level, and by the summer of 1862 she was the only domestic servant remaining in the Fleming house. If you find value in cases preserved this way through court records, testimony and contemporary documents, consider liking the video and subscribing to the channel, and let me know in the comments where you are listening from. Now, back to the record. By the evening of Friday, the 4th of July 1862, the household at 17 Sandyford Place was in a state of partial occupation that was entirely ordinary for a prosperous Glasgow family in the summer months. John Fleming, the accountant, had departed for Dunoon, a coastal town on the Firth of Clyde, where a portion of his family was spending the summer season. His sister Margaret Fleming had also departed. The habit of summering at the coast was common among households of the Flemings standing in the commercial Glasgow of the period, and it was equally common practice to leave the family home in the charge of the household's domestic servant during such absences. The only family member remaining in the house on Sandyford Place was John Fleming's father, James Fleming Sr., an elderly man who had come originally from Cumbernauld and who was by 1862 87 years of age. He occupied a bedroom on the dining room floor of the house, the floor above the kitchen level, distinct from the sunk flat where Jessie McPherson slept and worked. He was, so far as the subsequent investigation established, the only other person present in the house on the night the events in question took place. The two of them then, James Fleming Sr. and Jessie McPherson, were the occupants of 17 Sandyford Place on the evening of the 4th of July. Contemporary accounts record that at approximately 9:30 that evening, James Fleming Sr. retired to his bedroom on the upper floor. What occurred in the hours that followed in the rooms below is the central question of the entire criminal and legal record of this case. The investigation, the trial, and the decades of public debate that followed were all in one way or another attempts to answer it, and no answer was established in the courts or entered into the official record with. What is established is that at some point on the night of the 4th of July, or in the early hours of the morning of the 5th, Jessie McPherson was killed in her bedroom and in the kitchen of the sunk flat. She was struck approximately 40 times with an iron meat cleaver, the blows directed at her head, face and body. The violence of the attack was considerable. Blood was found throughout the bedroom, across the connecting lobby and in the kitchen. The floor of the kitchen and the bedroom had been partially washed down after the attack. The face, chest and neck of the body had been cleaned. Bloody footprints remained on the floor despite the washing, and these footprints would become among the most significant pieces of evidence in the proceedings that followed. Items of clothing belonging to Jessie McPherson were missing from the rooms. A quantity of silverware belonging to John Fleming was also missing from the house, including 6 ladles, a fish slice, a soup dispenser, and a sauce spoon. James Fleming Sr. remained in the house throughout the entirety of the weekend of the 4th to the 7th of July, 1862. He later gave it as his account that he had not known Jessie McPherson was dead, that the door of her bedroom had been locked, and that he had therefore had no occasion to discover her condition. This account was entered into the official record and formed part of the testimony and evidence at the subsequent proceedings. Whether the account was truthful was a matter that the courts were ultimately required to consider at length, and that the public and press considered at greater length still, without resolution. The milkman, George Peyton, visited the house on the morning of Saturday, the 5th of July, in the ordinary course of his rounds. His testimony at the subsequent trial established that the external appearance of the household on that morning gave no indication of any disturbance. He observed the house from the outside and received a response from within, indicating that the household was in order. The weekend passed. The door of the basement bedroom remained locked. On Monday, the 7th of July 1862, John Fleming returned from Dunoon. The circumstances of the discovery were entered into the record as part of his testimony at trial. He reported to the Western District Police Office at approximately 4:15 on the afternoon of the 7th of July that the body of his servant, Jessie McPherson, had been found in the locked basement bedroom of 17 Sandyford Place. The body was lying on its back on the floor of the room, in front of the bed. The bedclothes were extensively blood-stained. The room bore the evidence of a severe and sustained attack. The discovery on the 7th of July, 1862, ended the question of whether Jessie McPherson was alive. It opened a different set of questions, which the investigation was now formally required to address. The investigation of the Sandyford Place murder was the first case assigned to the detective branch of the Glasgow police. It was also the first Scottish police case in which forensic photography was employed as an investigative tool. A Captain Robb is named in contemporaneous press accounts as directing the search activities at and around the premises. Officers were dispatched to the house. Statements were taken from those present and from those who had been in the vicinity of Sandyford Place in the relevant period. The scene at the sunk flat was examined and recorded. Photographs were taken of the bloody footprints found on the floor of the kitchen and bedroom, these photographs constituting the record from which forensic comparisons would later be drawn. Public and press suspicion attached immediately to James Fleming Sr. The Falkirk Herald reported on the 10th of July that the elder Fleming had been apprehended, and the Glasgow Morning Journal of the same date noted that public opinion had concentrated upon him from the earliest days of the inquiry, questioning why he had not been immediately taken into custody. He was briefly held and then released. The investigation then turned toward a different individual. Inquiries into the disposition of the missing silverware led officers to a pawnbroker. The items had been presented by a woman giving the name Mary MacDonald. Officers identified Mary MacDonald as an alias used by Jessie McLachlan, the woman who had previously been in service at the Fleming household alongside Jessie McPherson, and who remained McPherson's closest personal friend by the summer of 1862. McLachlan was living at that time with her husband and their young son, approximately 3 years of age, in a tenement flat in Glasgow. The flat was shared with at least 2 lodgers, and the financial circumstances of the McLachlan household were described in the evidence as strained. Officers examined the McLachlan premises in detail. Bloodied clothing was recovered from the dwelling. A search of the clothes leading to the flat included the raising of flagstones in the investigation of further missing items. Jessie McLachlan was asked to provide a declaration before Alexander Strathern, Sheriff Substitute of Lanarkshire, on the 14th of July, 1862. She gave a further declaration on the 21st of July. In both declarations, she initially denied having been present at 17 Sandyford Place on the night of the murder. These denials were inconsistent with the physical evidence accumulating against her, and the investigation proceeded on the basis of her arrest. The forensic comparison of footprints formed a notable part of the investigation's documented procedure. Jessie McLachlan was asked to place her foot in a vessel containing cow's blood and then to step upon a plank of wood. The resulting impression was compared to the photographs taken of the bloody footprints at the scene on Sandyford Place. The match between the photographic evidence and the impression produced from McLachlan's foot was entered as evidence. It was an unprecedented application of photographic technology in Scottish criminal investigation, and its use was recorded as such in subsequent accounts of the case's forensic history. The husband of Jessie McLachlan was also temporarily apprehended in connection with the inquiry. He was released after it was established that he had left Glasgow on the morning of the 4th of July and had not returned during the period material to the case. The investigation's attention remained on Jessie McLachlan. The investigation had now produced, through the identification of the alias Mary MacDonald, the recovery of bloodied clothing, the forensic footprint comparison, and the inconsistencies in McLachlan's declarations, a body of circumstantial evidence that the prosecution considered sufficient to proceed to trial. The investigation entered the formal committal stage before Alexander Strathern, whose role as the receiving magistrate was later attested at trial. The case was committed to the Glasgow Circuit Court of Justiciary. A post-mortem examination was conducted on the 8th of July 1862 at the premises of 17 Sandyford Place by warrant issued by Alexander Strathern, Sheriff Substitute of Lanarkshire. The examining physicians were Dr. Joseph Fleming, police surgeon stationed at Anderston, Glasgow, who bore no relation to the employer's family, and Dr. MacLeod, who conducted the examination. Dr. Watson had attended the scene as the first physician on the scene prior to the formal post-mortem proceedings. The body was found lying on its back on the floor of the bedroom, close to and in front of the bed. The bedclothes were extensively blood-stained, consistent with the violence of the attack having occurred in or near the bed before the body came to rest on the floor. The cause of death was determined to be multiple blunt force trauma injuries, produced by repeated blows from a heavy implement. The iron meat cleaver, to which contemporary accounts attributed approximately 40 distinct blows delivered to the head, face and body, was consistent with the injuries identified at post-mortem. The findings established that the death had occurred on the night of the 4th of July, or in the early hours of the 5th, though the precise time could not be determined from the post-mortem findings. The physicians also noted that the face, chest and neck of the body had been washed prior to its discovery on the 7th of July. This detail was entered into the medical record and became a matter of significant interpretive dispute in the subsequent trial. The partial washing of the floors was noted alongside the cleaning of the body's visible surfaces. These findings were entered into the official record and formed part of the medical testimony presented at the Circuit Court proceedings. The formal preliminary proceedings in the case were conducted before Alexander Strathern, Sheriff Substitute of Lanarkshire, through the month of July 1862. Strathern received the declarations given by Jessie McPherson on the 14th and 21st of July and issued the warrant for the post-mortem examination. The Procurator Fiscal in Glasgow, William Hart, was involved in the preparation of the case for trial, and both Strathern and Hart would be called to attest to the declarations at the subsequent Circuit Court proceedings. The preliminary record established the basis on which the case was to be prosecuted, and the committal to the Circuit Court of Justiciary concluded the preliminary stage of the legal proceedings. The trial of Jessie McPherson commenced at the Glasgow Circuit Court of Justiciary on Wednesday, the 17th of September 1862. The court sitting also referred to in some contemporaneous accounts as the Old Court. Jail Square, Glasgow, Scotland, at this period, operated under Scots law, with jurisdiction in murder matters vested in the Circuit Court of Justiciary, a court distinct in its constitution and procedure from the English Assizes or the Old Bailey. The proceedings lasted 4 days, concluding on Saturday, the 20th of September. The court is recorded in the evidence as having sat for approximately 11 hours on each of the first 3 days. The presiding judge was Lord Deas, George Deas, Lord Deas of the Court of Session. The prosecution was led by Adam Gifford, Advocate Depute, assisted by Andrew Muir, Advocate, with Andrew Murray, Writer to the Signet, as Crown Agent. The defence was led by Andrew Rutherford Clark, with Robert MacLean and Adam Bannatyne as advocates, and J.A. Dixon, Strachan and W.M. Wilson as agents for the accused. Jessie McPherson was charged with the murder of Jessie McPherson Richardson on the 4th or 5th of July 1862, within the house of John Fleming, accountant, 17 Sandyford Place, and with the theft of the silverware and clothing belonging to the victim. She entered a plea of not guilty from the dock, stated in a firm voice. A formal special defence was entered on her behalf to the effect that the murder had been committed by James Fleming Sr. The prosecution presented its case through the evidence of witnesses including John Fleming, who had reported the discovery of the body, Margaret Fleming, who had been absent at Dunoon but was able to speak to the household arrangements, Dr. Joseph Fleming, who attested to the post-mortem findings, and George Peyton, the milkman, whose testimony addressed the appearance of the house on the Saturday morning. The prosecution's central evidential argument rested on 4 pillars: the identification of Jessie McPherson as the woman who had pawned the missing silverware under the alias Mary MacDonald, the bloodied clothing recovered from McLachlan's dwelling, the forensic comparison of the footprint at the scene with an impression taken from McLachlan's foot using the photographic evidence obtained by the detective branch, and the initial false denials McLachlan had given in her declarations to the effect that she had not been present at the house on the night of the murder. Inconsistencies between her various early statements formed an additional part of the Crown's case. The defence met each pillar of the prosecution's case and advanced the alternative account entered in the special defence. Counsel for McLachlan argued that James Fleming Sr. had been the sole occupant of the house with Jessie McPherson throughout the entire weekend following the murder, that his claim to have been entirely ignorant of the servant's death for a period of 3 days, with the locked bedroom door as his sole explanation, did not withstand scrutiny, and that his prior history of sexual conduct with a servant, which was put before the court as evidence of character and motive, established a credible basis for his having attacked McPherson if she had refused his advances. The defence also addressed the washing of the victim's face, arguing that this act was inconsistent with the conduct of a cold-blooded perpetrator intent only on concealment, and was more consistent with a person who had arrived at the scene in the aftermath of the attack and had been moved to some act of compassion toward the dying woman. Andrew Rutherford Clark's conduct of the defence was noted in contemporaneous press accounts as vigorous and thorough. The special defence itself, pointing directly to James Fleming Sr. as the actual murderer, was an unusual and formal procedural step that gave the alternative account the status of a declared legal position. Lord Deers delivered his summing up to the jury at the conclusion of the evidence. The address lasted more than 4 hours. Contemporaneous legal commentary described Lord Deers's conduct of that, summing up in terms that remained part of the case's documented record for the following century and more. A law journal of the period was quoted as saying that he had placed his foot fiercely into one scale of justice and kicked at the other, a characterization that was widely reproduced and that has remained the standard description of his conduct of the case in the subsequent literature. The summing up gave no meaningful acknowledgement of the doubts raised by the defence or by the weight of the evidence against James Fleming Sr. The jury retired to deliberate. The duration of their deliberation was recorded variously in contemporaneous and subsequent sources as between 15 and 19 minutes. The jury returned a verdict of guilty, unanimous, following the return of the verdict. Andrew Rutherford Clark rose and read at length from a statement that Jessie McLachlan had prepared. The statement had not been placed before the jury during the trial itself, but was now entered into the public record as her own account of the events of the night of the 4th of July. In this account, McLachlan described having visited 17 Sandyford Place that evening, at the request of her friend Jessie McPherson, encountering James Fleming Sr. in circumstances that implicated him directly in an attack upon McPherson, and remaining in the house with the dying woman, tending to her and attempting to assist her, before ultimately departing with the silverware and the clothing at Fleming's direction. Lord Dees responded to the reading of this statement from the bench, characterising it as a tissue of wicked falsehoods. The statement was entered into the record of the proceedings and became the basis of the public debate that followed immediately upon the conclusion of the trial. The verdict was entered in the record of the Glasgow Circuit Court of Justiciary on the 20th of September 1862, the case as presented by the Crown, on the basis of circumstantial evidence accumulating against Jessie, had been accepted by the jury in a matter of minutes. What had occurred in the sunk flat of 17 Sandyford Place on the night of the 4th of July remained, in the strictest legal sense, a matter entered as settled by the verdict. In the public sense, it was anything. The court proceeded to sentencing on the 20th of September 1862. Lord Dees pronounced the sentence without qualification and without any acknowledgement of the grounds raised by the defence or of the alternative account McLachlan had placed before the court through counsel. The sentence was death by hanging. Execution was scheduled for the 11th of October 1862. Jessie McLachlan was removed from the court and placed in custody to await the carrying out of the sentence. The immediate public reaction to the verdict and sentence was extensive and largely hostile to the outcome of the proceedings. The conviction and the conduct of Lord Dees's summing up were challenged in the Scottish press within days of the verdict. The Glasgow Morning Journal, the Dundee Courier, and other Scottish newspapers published commentary questioning the verdict and arguing that the logical implications of McLachlan's statement, if any part of it were accepted as credible, made it necessary to revisit the position of James Fleming Sr. The Dundee Courier of the 23rd of September, 1862, described the case as among the most disturbing narratives of violent crime to have entered the Scottish criminal record in many years and called for further action. The Glasgow Morning Journal argued that if the Home Secretary were to accept any degree of reduced culpability for McLachlan, the logic of that position required a warrant for Fleming's arrest. Public opinion in Glasgow and across Scotland sided overwhelmingly with McLachlan, and the central point of public grievance was not complicated. James Fleming Sr. had been the only other person in the house with Jessie McPherson throughout the entire period of her death, and the 3 days during which her body lay in the locked room, and he had given an account of his ignorance of her condition that the public found impossible to accept. The sentence was not carried out on the 11th of October, 1862. In an action described in contemporaneous sources as unprecedented in Scottish legal practice, a court commission was appointed to re-examine the evidence in the case, prompted by the volume and force of public and press challenge to the verdict. The commission did not declare Jessie McLachlan innocent of any involvement in the events of the 4th of July. It did not formally overturn the conviction. What it produced was a finding sufficient to justify the commutation of the death sentence. The Home Secretary commuted the sentence of death by hanging to one of penal servitude for life. The Dundee Courier of the 2nd of December 1862 recorded the terms of the commutation and continued to press the argument that the Commission's conclusions, if logically followed, pointed to the necessity of action against James Fleming Sr. No such action was. Jessie McLachlan entered Perth General Prison to serve the commuted sentence of penal servitude for life. She was held at Perth for 15 years. The record of her conduct and circumstances during that period is not substantially documented in available sources. She was released on ticket of leave on the 5th of October, 1877. She was approximately 44 years of age at the time of her release. A newspaper account of her departure from Perth Prison noted that she was a woman whose name 15 years previously had been in everybody's mouth. She was not able to remain in Scotland in obscurity. During the years of her imprisonment, her husband and their son, who would by 1877 have been approximately 18 years of age, had emigrated to the United States of America. Jessie McLachlan followed them there after her release. She remarried at some point during her years in America, though the identity of her second husband is not recorded in available sources. She settled eventually at Port Huron, in the state of Michigan. She died there on the 1st of January, 1899, at approximately 64 or 65 years of age. The case she had been convicted of had preceded her across the Atlantic in the form of published accounts and press references, and she did not escape the association with it in her lifetime. Her death in Port Huron closed her own personal record. It did not close the record of the events at 17 Sandiford Place. The commutation of the death sentence had been unprecedented. It had not been accompanied by a formal declaration that the conviction was unsafe or that Jessie McLachlan had been wrongly convicted of the murder of Jessie McPherson. The legal position, as it stood in December of 1862 and as it continued to stand thereafter, was that the verdict of the Glasgow Circuit Court of Justiciary on the 20th of September 1862 had not been overturned. No pardon was ever issued. No formal exoneration was ever entered into the record. What the historical record accumulated in the years and decades following the trial was a body of commentary, scholarship and public argument that consistently raised the same questions the Scottish press had raised in September and October of 1862. The statement McLachlan had read from the dock through her counsel was examined at length by subsequent, and the Scottish legal journalist and writer William Ruffhead, whose collected writings on Scottish criminal trials constitute one of the authoritative secondary treatments of the case, argued that the statement's internal consistency, its ability to account for details McLachlan could not plausibly have known in advance of providing the account, was strong evidence of its substance. Ruffhead's formulation, which passed into the case's documented commentary, was to the effect that if the statement were false, a fictionist more extraordinary than Defoe had been lost to the prison system. The argument was not simply about sympathy for McLachlan. It was about the coherence of the evidence as a whole, and about the implausibility of James Fleming Sr.'s. The questions raised about Lord Dease's conduct of the trial became a fixed element of the case's record. His 4-hour summing up, characterised by the Contemporary Law Journal in the terms already noted, was cited in every subsequent serious treatment of the case as an instance of judicial conduct that improperly weighted the outcome. The jury's deliberation of somewhere between 15 and 19 minutes after 4 days of complex evidence was itself taken as an indication of the degree to which the summing up had shaped their approach. No formal disciplinary or appellate proceedings in respect of Lord Dease's conduct of the case were entered into the record. James Fleming Sr. died on a Tuesday in the second week of September at the country residence of his son in Dunoon. He was in his 90th year of age. A notice of his death appeared in the Dundee Advertiser of the 15th of September 1864. He had never responded publicly to the accusations entered against him in McLachlan's statement or in the subsequent public debate. He had never been indicted for any offence in connection with the death of his son, John Fleming the accountant, died at Dunoon in 1866, at approximately 50 years of age. Neither man answered in any formal legal proceeding for the events of the 4th of July 1862. The modern historical view of the case, as it has developed through the 20th and 21st centuries, does not accept the verdict of 1862 as a satisfactory account of what occurred in the sunk flat of 17 Sandyford Place. The weight of scholarly and popular opinion holds that the case against Jessie McLachlan as the sole perpetrator of the murder was seriously flawed, that the conduct of the trial by Lord Dease was biased against the accused to a degree that materially affected the outcome, and that the role of James Fleming Sr. in the death of Jessie McPherson was at minimum concealed and at worst constituted a greater culpability than the law was ever prepared to address. This is not a formally entered legal position. It is the position to which the secondary literature, from Roughhead through the later treatments of the case, has consistently arrived. A BBC One programme, Murder, Mystery and My Family, which broadcast an episode on the case in July of 2021, reached the opposite conclusion, upholding the original verdict on the basis of a reinvestigation of the evidence. That position is noted in the record of the case's continuing debate. It has not displaced the weight of the contrary view. The record of the investigation offers one further historical significance beyond the questions of guilt and justice. The Sandyford Place murder of 1862 was the first case assigned to the detective branch of the Glasgow police, that branch being newly established at the time the investigation was opened. It was also the first Scottish police investigation to employ forensic photography as a tool of evidence. The photographs of the bloody footprints at the scene at Sandyford Place forming the basis of the forensic footprint comparison that was entered as evidence against McLachlan at trial. These two facts placed the case at the beginning of a procedural history of some significance to the development of criminal investigation. The figure of Jessie McPherson herself occupies the centre of the case's title and its moral weight, and occupies a far smaller space in its documented record. What the record preserves of her is the fact of her death, the circumstances in which she was found, and a handful of details about her origins and her employment. She was raised in circumstances that the record characterises as involving a putative father who neglected her and guardians who are now no longer named. She came to service. She came to the Fleming household. She formed a close friendship with another woman in the same household who was also named Jessie, and whose fate, after the events of July 1862, was to be tried for her murder, convicted, imprisoned for 15 years, and then to leave Scotland altogether. The record gives Jessie McPherson's death a great deal of procedural attention. It gives her life almost none. The documents offer no account of what she said, what she hoped for, or what she understood about her circumstances in the summer of 1862. She remains in the record as the person in whose name the proceedings were conducted, and whose presence is established only by her absence from it after the night of the 4th of July. The Sandyford Place case entered the cultural record in Scotland almost immediately after the conclusion of the trial, through the extensive press coverage that the verdict and the commutation generated in 18, and it did not leave it. The case was treated at length by the Scottish legal writer William Ruffhead in his collected writings on Scottish criminal proceedings, which remained a reference point for subsequent scholars and writers who addressed the case. In 1960, the crime novelist Christiana Brand, best known for detective fiction, published a book-length account of the case under the title Heaven Knows Who, drawing extensively on the trial record, the declarations, and the contemporary press to produce what she described as a documented account of the events. Brand argued for McLachlan's innocence, or at minimum, for her reduced culpability, and she acknowledged that the case's complexity, including the multiple versions of events McLachlan had offered at various stages, made it genuinely difficult to resolve with certainty. The book was republished in 2016 and received a nomination for an Edgar Award. In 1961, the journalist Jack House published Square Mile of Murder, a volume covering 4 criminal cases associated with a particular area of Glasgow, of which the Sandyford Place murder was one. That volume was subsequently dramatised by the BBC in 1980. Television coverage of the case continued into the 21st century, with documentary treatment by Stevie Productions and by the BBC One programme already noted. The case is regarded in Glasgow as part of the city's recorded criminal history and has been featured in the public materials of the Glasgow City Heritage Trust in connection with the history of the Square Mile of Murder. What the case established in the historical record, beyond its specific facts, was a set of questions about the operation of the Victorian criminal justice system in Scotland that continued to be examined long after the formal proceedings had concluded. The class dimensions of the case, in which a working-class servant woman was convicted on circumstantial evidence, while an elderly man of professional respectability remained untouched by legal proceedings, despite being the only other occupant of the house at the relevant time, were apparent to contemporaries, and have been remarked upon by every subsequent commentator who has addressed the protection afforded to James Fleming Sr. by his social position, and the corresponding exposure of Jessie McPherson to the full force of a criminal prosecution conducted before a judge whose conduct was characterised as partial by contemporary observers, were not features of this case alone in the Victorian period. They were features of the system in which the Sandyford Place murder of 1862 placed them in unusually sharp relief. The case of Jessie McPherson closes the record examined here. The conviction was entered. The sentence was commuted. The question the public raised in September of 1862 was not commuted with it. The case entered Scottish memory. It has remained there. The verdict stood. The case became part of British memory.